Hi, I'm going to introduce our final panel. My name is Catherine Ferry, and I'm a third-year law student here at Colorado Law. I have the privilege of introducing our final panel, AI Speech and the First Amendment. So the First Amendment has long protected the speech rights of human and corporate speakers and listeners in the United States. But rapid advancements in artificial intelligence have led to a new era in which AI-generated speech can match or even surpass human speech in terms of sophistication and substance. This development has raised complex questions about the intersection of AI and speech. How does the First Amendment apply to speech generated by machines, if at all? Do individuals have a right to access AI-generated speech in the same way they do with human-generated content? What are the concerns about potential censorship and the role of the government in the realm of AI speech? This panel will explore the various implications of AI-generated speech on the First Amendment. Panelists will discuss whether the right to free speech and the right to information extends to the creation and dissemination of AI-generated content, and if so, to what extent. The panel will also explore the potential differences between AI and human speech, as well as the challenges it creates with speech that is potentially defamatory, misleading, or inaccurate. Ultimately, this panel aims to parse what the First Amendment future looks like in this new world of AI. Moderating this panel is Professor Blake Reid. Professor Reid is an associate professor of law here at Colorado Law and the director of Telecom and Platforms Initiatives at Flatirons. He previously directed Colorado Law's Samuelson Glushko Technology Law and Policy Clinic and was a staff attorney and clinical teaching fellow in First Amendment and Media Law at the Institute for Public Representation at Georgetown Law. His work on topics such as content moderation, platform carriage requirements, copyright, and disability access in the digital age have been published by journals including the Stanford Law Review, the George Washington Law Review, and the First Amendment Law Review. This panel will feature Eric Alston, scholar in residence at the Finance Division of CU Boulder, Dr. Newton Campbell, Director of Space Programs at the Australian Remote Operations for Space and Earth, Professor April Dawson, Associate Dean of Technology and Innovation and a Professor of Law at North Carolina Central University, and Professor Helen Norton, University Distinguished Professor and Rothgerber Chair in Constitutional Law at the University of Colorado Law School. I'm going to turn it over to Professor Blake Reid for the panel and to tell you more about our panelists.
All right, thanks very much, Catherine. Let's just keep it going for 1 second for our amazing students who do so much to help out with these events. This is normally where I extol the virtue of a student like Catherine and tell you all to go hire her because she's amazing, but I believe she is already employed. So instead, I encourage you to chat with her at the break and lament that you are too late. With that, I am delighted to turn to our panel today on the intersection of the First Amendment and AI speech. The last panel, we were talking about robots interpreting the Constitution. It's funny how the tables turn. Now the robots are coming and asking for the Constitution's help. So we will decide whether they might avail themselves of that. So the way we're going to do this, we're going to talk through 4 topics. The first one is going to be the nature of the AI speaker and speech. Then we're going to turn to the potential harms of AI-generated speech. We will then turn to the regulation of AI speech and what the First Amendment might have to say about that. And then finally, we'll turn to the Supreme Court's recent jurisprudence on the First Amendment and how that might cross-cut. The way we're going to structure this, I'm going to bounce back and forth between our 2 expert con law scholars to start things off on each question, Helen and April, and then I will look down the table to our technologists and business experts for some retorts and rejoinders. I have confirmed that no one on the panel is an artificial intelligence. You are getting 100% human speech here, so let's get into it. So Helen, you have written some of the path-breaking work on the nature of AI speech under the First Amendment, but I was taught by the earlier sessions that actually we don't need constitutional interpretation to be done by humans anymore. We can just ask ChatGPT to do it. So I'm sorry to tell you, I asked ChatGPT if it had First Amendment rights, if what it says is protected by the First Amendment. And it says, as an AI developed by OpenAI, I don't have legal rights or protections like those provided by the First Amendment. So I think we're done, but if you want to rejoin that, go ahead.
Thanks, Blake. Well, I'm gonna proceed as if I didn't hear that. But in thinking about whether or not the First Amendment has anything to say about AI, I think it's helpful to start by thinking about, why do we have a First Amendment? What is the work that we think and hope that the First Amendment does? What are the values, the purposes that we hope that it's going to achieve? And it turns out that there's multiple answers to that question. One possible answer is that we should protect speech because speech is a valuable end in and of itself. That speech is intrinsically valuable because it's central to our individual expression, to our autonomy, to our dignity, to our self-fulfillment. And so if you take this view of why we have a First Amendment, our own speech should be protected because it's fundamental to how we develop our identities and express our ideas. It's part of our being fully human, such that it's just wrong for the government to interfere with our humanity by regulating our speech. And if that's your theory of the First Amendment, if that's your answer to the question, why do we have a First Amendment? What is it supposed to be doing? Then speech is protected even if nobody other than the speaker finds it terribly interesting or important. Speech should be protected solely because of its value to the speaker's own personhood. And if you take that view of the First Amendment, we probably should not understand the First Amendment to cover AI speech, and your findings are correct. But there are several other possible answers to this question, why do we have a First Amendment? What is it that we hope that the First Amendment would do? Why do we think speech deserves protection? And these are more instrumental in nature. They are arguing maybe not that speech is a valuable end in and of itself, but that speech is a means to achieving valuable ends, other important objectives. And that speech can be valuable in achieving those objectives regardless of its source as human or AI. What do I mean by these sorts of ends or objectives that speech might help us achieve? Well, one is the dissemination of ideas and knowledge through the marketplace of ideas. This is the proposition that speech is valuable because it exposes us to ideas and facts and opinions that help us figure out how we want to live or help us figure out how we want to think about important problems. Another instrumental argument for protecting speech is that we should protect it because it's a means to the important end of democracy. And this is the idea that a healthy democracy depends on the exchange of free thought and expression and dissent, where people can discuss and disagree about public policy and candidates and the government. And I can talk about this in very critical as well as very celebratory ways. Now, those three theories I've discussed so far are all what you might call affirmative theories of the First Amendment. In other words, they're affirmative answers to the question of why the Constitution protects speech, because they say speech is affirmatively valuable, it's affirmatively good, so we should take care to protect it. But there's another very different answer to this question of why the Constitution protects speech, and this is what some call a negative approach to the First Amendment. Negative First Amendment theory doesn't focus on why or when or whether speech is terribly valuable. Instead, here the idea is that the government is too often dangerous in its capacity to abuse its regulatory power. The government is at times self-interested or biased in other ways or just clumsy in its regulation of speech. And for these reasons, we should take care to limit the government's power to regulate speech because we don't trust it to do so competently or disinterestedly. And this is called negative First Amendment theory because it's all about a negative value, distrust of the government, the idea that the First Amendment maybe is more about our fears of the government than about affirmatively celebrating speech. So these are multiple possible answers to the question of why the Constitution protects speech, and the Supreme Court is interested in them at various times, and commentators and lawyers are interested in them various times. They're not mutually exclusive, and it's very common for a judge or a scholar or a lawyer to embrace more than one of them at the same time. But once we start to think hard about why the Constitution protects speech, we can see that most of these values, these purposes, are at least as important to listeners as they are to speakers. So in other words, we value under these views, and the Constitution protects expression because it provides certain affirmative benefits to listeners and not just speakers. So expression under these views, including AI expression, is valuable when it facilitates listeners' democratic self-governance. AI speech and other expression is valuable when it enlightens listeners by exposing them to a marketplace of ideas and facts and opinions. And AI speech and other expression is valuable when it informs listeners' choices and thus the exercise of their autonomy. In other words, AI speech can provide value to listeners just like human speech. So those are the reasons why the First Amendment can be plausibly understood to apply to AI speech.
So Helen, before I open it up to the rest of the panel, just a quick follow-up on your last point. How do we know, how do we evaluate, what's the baseline for understanding when AI has served listeners' interest in the way that you just described? Is that something that we can measure? Where do we source the content of that inquiry? How do we know? How do we apply that?
It seems to me that in answering that question, that the source of the speech doesn't matter. And you could just as easily have said, how do we know that any speech, how do I know that your speech is terribly valuable?
It's pretty straightforward, but go on.
Right? I mean, I don't know that it lends itself easily to metrics, right? It is ultimately up to the listener to judge the value of the speech. And facts and opinions, ideas can be useful to them in terms of affirmatively shaping their behavior and their ideas, and they can be helpful to them in finding something that they want to push back on. And this is part of the idea of the marketplace of ideas, is that the speech that repels us may be as valuable as the speech that attracts us, because it helps us identify what's good and true or wise, at least for us.
With that, happy to open it up to the rest of the panel. April, can I come to you for a quick reaction, then we'll bounce down the way.
Yeah, so first, thank you for having me here. And Helen, thank you for that wonderful kind of description of the affirmative rights, the negative rights. You framed that so wonderfully. And as you were talking, and I kind of knew where your conclusion was going, I wanted to get your thoughts on, typically when we're thinking about the First Amendment, it's an individual person who has that right. So if AI, ChatGPT, there's a First Amendment right for that information to be, put out, in the event there's regulation of that, who would assert the First Amendment right? How would we see that?
Yeah. Right, so lots of good questions about operationalizing the idea. And that's maybe a set of pragmatic reasons. What if you're on the fence, you can construct arguments for why AI speech might get First Amendment coverage, and you're constructing arguments for why AI speech might not want to. Those pragmatic limitations might be a reason to go on the side of, well, maybe it's just too much, it's more work than it's worth. But it probably is worth the work. And it's definitely true, Professor Dawson, that you're anticipating that we would probably have to be more creative about our doctrine in order to operationalize that. But it seems like those are doctrinal problems that could be solved. We could, for example, trace the duties and responsibilities that come with AI speech back to their human owners, right? Whoever unleashed them. I think that's the most common way to think about the possibility of operationalizing it. There's some folks, I don't know that I'm quite ready to go there, but some folks are saying, well, as AI gets more and more advanced, AI itself might be responsible for maybe being enjoined if it has been found to violate folks, if it's found to defame folks or to threaten folks or to steal from them. And this is hard for me to imagine, right? Both how they could respond to an injunction and also maybe how they could pay a judgment. So why the more attractive, I think, idea to most folks right now is to trace it back ultimately to a human owner, operator, or prompter.
So I know we're going to go down the rabbit hole on regulations that do that tracing of liability back to the legal owners. But before we move on from this notion of treating AIs as a distinct entity onto themselves. I want to go down the way, and I'm going to start with Eric and then come to Newton. Eric, I know you had some notes in our discussion before the panel about the cognition of AIs and what they are doing. Is there anything to be gleaned from thinking about AIs as speakers, separate from the notion of what they output as speech?
Yeah, absolutely. And I think a common sort of understandable misconception from the strength of First Amendment protections that speech does enjoy is that in some sense, all speech has value. And I'm not sure that's the case. I've encountered, and frankly, I'm known at the engineering firm I consult with as GPTE, in the sense of I'm known to go on far too long. But I've been thinking a lot about, and I'm working on an article that might actually appear in this special issue, about the limitations of AI for the process of adjudication, what it is essentially to judge something. And I actually link most of the benefits that were described about why we protect speech in the first instance as interestingly linked to my problems I have with AI as any form of judge. I think AI surfaces existing information remarkably effectively, setting aside the issue of hallucinations, which are pretty well understood as a problem. But I think the notion that hard cases make good law, and that's a very debatable statement itself, but essentially the higher courts have to adjudicate really hard cases. And ultimately, they have to weigh trade-offs in ways that I call commensurating the incommensurable. And I've written about rights trade-offs in Ecuador's constitution, for example, but I think the problem is much deeper than that. And I trace it all the way back to the parable of King Solomon, which is, I think a lot of people who think, wow, what a clever judge he was in getting the revelation of the right answer, are missing the deeper point, which is King Solomon was presented with a case where one party had to lose completely. It was a binary outcome. One party got the baby. You could not split the baby. And so for me, the essence of some of our most important cases are ones where a judge has to use something fundamentally human, sort of, and ultimately something that cannot be distilled to easily commensurable quantities that you just weigh off against one another. When the answer is obvious, often the parties settle just outright. And so for me, my issue is a lot of these purported benefits, and benefits I believe in, to be clear, of speech, I think rely on an expression surrounding the harder issues that mankind faces, including in our own self-governance, but the marketplace of ideas also hinges on trading off between areas we're uncertain about. You don't see people, calling the marketplace of ideas arguments that gravity doesn't exist or that the earth is flat. It's thought to be that the issues over which there is substantive disagreement among members of society are ones in which it is beneficial to speak upon. But my issue is the way an AI algorithm generates speech is it is not weighing these really hard, I think impossible, for a machine to effectively adjudicate trade-offs. It is surfacing existing information and perspectives in a replicable way. And so for me, I view some issues with the way in which a large language model is generating an answer. That feels very foreign to me relative to the sort of King Solomon, even King Solomon in our own minds, in deciding how we want to proceed on a particular issue of personal identity. And so for me, I view something essentially different in the way large language models are generating information and the way in which our human cognition generates speech in the important areas in which it does receive protection under the First Amendment.
Helen, I know you'll want to have a rejoinder to that, but before we do that, I want to go to Newton for his reaction.
Sure. I don't know how often you've been to Silicon Valley, but I definitely have encountered plenty of humans that are surfacing what seems to be complex ideas by just regurgitating what they've heard. So, Helen, as I was thinking about this topic as well, pretty much all of the things that you stated really gelled with me when I think about why one would want to protect AI speech. And really, for me, that marketplace of ideas really hits home, right? The diversity of what you can see by having something that is pulling in that information, but synthesizing it, and it has the ability to synthesize it in a near infinite probability distribution space, is valuable inherently to the marketplace of ideas. When I'm thinking about this topic, I don't apply some form of agency to AI, ironically, given that AIs are agents, right? I don't apply some sort of agency. All I see it as is an ability to help humans in different ways, whether that's positive or negative, whether that's human beings wanting to execute something positive, like looking at climate change, or creating vaccines, or sometimes in the negative case, right? Subverting democracies, things like that. The idea is to present humans with additional knowledge, additional expression. And I only see regulations or restrictions on that as regulations or restrictions on human beings having that knowledge and expression. So I guess that's really all I have to say about that. I acknowledge the dangers of it, but at the end of the day, it is, for now, it is still made to serve humans. You're not seeing, an AI agent that's out there in the wild, unowned by anyone. A human being had to let that loose at some point. We will get there at some point, but for right now, the end goal is to serve human beings and human purposes in some way. And I think from a tractability standpoint, the tractability of the problem, it best serves us to figure out, all right, how do we trace responsibility back to the right humans when things go wrong?
Helen, your rejoinder before we move on to regulations on the role of humanity in constructing speech as such under the First Amendment.
It's just two quick, I don't know that they're rejoinders, but responses. I mean, in part, maybe we're not being accurate when we talk about this as AI speech, right? I mean, maybe at least now, because you could trace it to the human prompter, if maybe. But what it's doing so far is generating something based on what humans have said or thought or written so far. So it's not so clear that it's easy to disentangle AI speech from human speech, which is why I'm agnostic as to whether or not we should protect what we think is AI speech under the First Amendment. I think you can construct plausible arguments for why you can, and I think you can construct plausible arguments for why you can't. What really matters to me, and we'll talk more about this when we get to regulation, is a doctrine that focuses on human listeners, because I agree that the whole point of AI, whoever you think is generating it, is to serve human listeners' interests. And as you'll see later, I think we should understand the First Amendment to protect AI speech when it serves human listeners' interests. And I think we should understand the First Amendment to permit the government to regulate AI speech when it interferes with human listeners' interests.
So to transition us into that conversation about regulation, April, I want to come to you next. We have heard a lot of discussion today, including on the first panel, about the kinds of harms that AI speech might cause both to listeners, to the public, and we can think of other ways we might conceive of harm. April, what are the kinds of harms that you see as being most salient with AI-generated speech, and how do they differ, if at all, from the corresponding harms of human speech?
Mm-hmm. Yes. So of course, the most obvious one is hallucination. So we have misinformation. We have seen this. I'm sure everyone has heard about the attorneys who have, without thoroughly reading the cases that ChatGPT provided, included them in their briefs. There have been far too many lawyers who have just taken the information that ChatGPT provided and included it in the brief. And so these are perfect examples of hallucination and how these hallucinations can cause harm if the user is not diligent. So when hallucinations rise to the level of causing specific harm or causing defamatory information to individuals, there we can see another level of harm. So not just misinformation, but defamatory information. And there's actually a case out of Georgia, Walters v. OpenAI. And this was a case where you have an individual, he was a DJ in Georgia, and a reporter who actually knew this particular individual did a search on a lawsuit that had been filed against this company and asked ChatGPT for information about this particular suit. And ChatGPT came back and said, Walters was actually the defendant in this suit. He was being sued for embezzlement when he was an employee at this company. Well, Mr. Walters was never an employee at this company, did not engage in any embezzlement at all whatsoever. But this was information that ChatGPT provided to this reporter. So the reporter didn't do anything further with that information, didn't further publish the information, did communicate with Mr. Walters. And Mr. Walters has filed this defamation action against OpenAI. So this is a really interesting case because it allows us to think about if we do have some agency either to the technology or to the company that has created the technology, what does defamation look like in this space? So OpenAI, they requested removal to federal court. They ultimately withdrew that. But in their pleadings to the federal court, they actually filed a motion to dismiss. The case is back into state court. They haven't yet filed a motion to dismiss within that suit. But in looking at the federal motion to dismiss, it's very insightful. We know what OpenAI's arguments will be. So the first argument is that the content that was generated by OpenAI is not defamatory as a matter of kind of definition, right? ChatGPT, any of these generative AI tools, particularly if we're talking about the text tools, they are not providing facts. That's not what they do. They are coming up with, based on statistics and probabilities, what's the next best word based on the prompt that they were given. So it's not facts that was being generated. It was the pattern based on the prompt that was given. So OpenAI's argument is this was not meant to be factual in the first place, therefore it could not be defamatory. The other arguments that are raised by OpenAI is that there was no publication. So of course, with defamation, there has to be some publication. This went to one specific individual. It's not as though you have a newspaper that is publishing something or a book that's being published and being, given to, a whole swath of people. This is one individual who was requesting information. It's also unclear, because we know how these tools work, if someone else put in the exact same prompt, if they would have gotten the exact same result. So OpenAI's argument is there was no publication. It went to one person, and that person communicated it to Mr. Walters, but there was no mass communication to it. The other argument was that because Mr. Walters is known within his community, he's a DJ, there needed to be a demonstration of actual malice because he's a public figure. And again, this is really interesting because when we're thinking about the generation of this text and we're thinking about if there is intent on the part of the technology, there is not, right? These are technological tools that are being used to help individuals, so we don't have that intent. So actual malice, you communicated this information knowing it was false, or with reckless disregard as to the truth or falsity. And in this situation, again, kind of understanding the underlying technology, ChatGPT doesn't even know who Mr. Walters is, right? It kind of looked at the information that was out there based on the training data. It may have even pulled some information from the internet, but there was no understanding, right? It's just pulling together text based on probabilities. So that's OpenAI's argument there. The other thing that I wanted to touch on before we get some other kind of reactions is when we're thinking about artificial intelligence, and not just generative AI, but any type of artificial intelligence that is allowing for the communication of information at scale and at speed, we have to think about harm that may be caused within elections. So 2024, there are over 600 countries that will be engaged in elections this year. And when we're thinking about, of course, deep fakes, when we're thinking about sexual images, when we're thinking about audios, all of this can give rise to an acceleration of harm that has always existed. So when we're talking about misinformation and disinformation in the election context, that is not new, that has always existed. But if you are able to, as was the case in New Hampshire in January, create an audio file that is exactly, President Biden's voice, because they were able to pull that information and use a tool that's widely available to have him say to New Hampshire voters, you don't have to vote in the Democratic primary because it's not necessary. It's only going to help the Republicans, right? Don't vote. And I don't know how many folks have actually heard the audio, but there's no way that you can, just based on listening to that, know that it is a deep fake. And so when we think about AI and the harms of AI, the fact that there can be a significant impact on the misinformation and disinformation and manipulation in the electoral context, that raises a lot of concerns. And the last point that I'll make with respect to disinformation and manipulation is to kind of focus on pornographic videos. The vast majority of victims, when it comes to that type of generative AI, it's women, right? So when we think about female candidates, when you think about election workers, when you think about the threats and harms and intimidations that come from that type of threat, those that are being targeted are women, people of color. It happens at the national level. We know, we will hear about it, there will be actions that are taken. So we saw this with the Taylor Swift situation. Well, if I'm running for city council or for school board within my small little town in North Carolina, it is so easy for people to target me as well, but CNN's not going to pick that up necessarily, right? So these are some additional harms when we're thinking about AI and harms that we need to think about beyond just, kind of First Amendment rights.
Well, thanks, April. That's a terrific taxonomy. I think you teased out both sort of retail harms and then maybe we call wholesale or distributional harms. And I think we can pick both of those up. But I want to zoom in really quickly on the sort of retail piece. And Helen, come to you with a question about defamation, which is, it sounds like inherent in the arguments OpenAI is making in that case that April just described. There are a couple of things emerging. One, they're sort of saying the outputs of this are definitionally non-speech. There's some. This is a product of math. This is not sort of ontologically what we would think of as speech. And then the second, I guess, thrust of it is to the extent there's some speech there, that's arguably coming from the user. This is a mirror on what the user is feeding in and maybe on what we have trained the model with. This is not us. And obviously there's a familiar refrain in technology law, debates the intermediary says not our fault. What do you make of those arguments, given your conception of AI speech?
Yeah, I so appreciate those examples. And as you were talking about hallucinations and deep fakes, I was thinking, well, those are both types of inaccuracies, right? They're types of false or misleading speech, which is certainly a type of harmful speech that humans are very capable of producing. But you're helping us understand that, at least under some circumstances, AI speech can cause harms that are distinct from the harms caused by human speech. At least maybe exacerbating the harms that we see with human speech. So the harms are at least different in degree, and maybe sometimes they're different in kind. And so I was interested, as you walked through OpenAI's defenses, I was trying to figure out in what ways do those defenses map onto defenses that we see in traditional defamation cases involving human speakers, and in what ways does the AI speech invite brand new defenses that are unique to AI. And my intuition is that even though I'm open to the possibility that AI speech deserves some First Amendment protection to the extent that it's valuable to listeners, I just can't imagine any circumstance under which we would give AI speech greater protection than we would give human-generated speech. And the law of defamation, I think, is a terrific example. The law of defamation is a balancing. The tort of defamation seeks to make the victim of defamation whole for the very serious harms to their reputation that they've suffered, while balancing those protections by crafting rules that ideally will not over-regulate speech such that it chills speakers from engaging in valuable speech, like valuable criticism of the government, where they might have some inaccuracies. And here, in this particular case, the human tort plaintiff, defamation plaintiff, has the same sort of reputational harms that we see in traditional defamation cases, but the AI speaker does not have the threats to chilling that we worry about in traditional defamation law. So, long story short, I am unsympathetic to OpenAI's defenses.
Sure. So I'm going to ask what's likely a 1L question here. If I have an engineering textbook, okay, if I author an engineering textbook and there is an uncorrected equation in that textbook, and an aerospace engineer designs an aircraft wing based off of that uncorrected equation, whether that equation was used for the testing of that aircraft wing and deceive them into thinking, oh, this aircraft is ready to go. That plane gets into a crash. Is the author of that textbook liable? This is not a snarky question. I have no idea. I'm a technologist.
Defer to our con law experts on that one, I
Well,
think.
I was looking for the tort law.
Yeah, I mean, potentially negligence, right? If you know that this textbook is being used for this purpose, and it's reasonably foreseeable that people will rely upon the equation, and so you might be able to establish liability there, but there's also another issue, which is causation, right?
Yeah.
So should it be the person who did the textbook or the ultimate builder of the aircraft? Isn't it reasonable for them to double check?
I would argue it's the latter, especially in an arena where everyone has Lagrange equations. People there's a million textbooks you can get. This is just one. So would the same not then apply even in the OpenAI case, right? You could have gone there for knowledge, but you could have also gone to some of these other platforms for knowledge. You could have gone to other data sources. Is that not something that we're going to consider when we're going to a group like OpenAI and saying, hey, they're liable? Is that just again from a legal standpoint?
From a defamation standpoint, I think that doesn't matter. So it's if the Washington Post defames me, I can still go after the Washington Post, even though the New York Times says the nicest things about me, right? It's the fact that the Washington Post, I would go after them as the defendant.
Okay. Yeah, I mean that I think it kind of gets to some of the core of who effectively takes the blame in some of these cases, though. If we have an AI that's telling you that this information about a journalist, or like you said, stating something as fact, when it's not really fact, it's kind of up to the end user, I would assume, to say, hey, I'm going to actually go check my sources. And within journalism, there should be some sense of journalistic rigor, if you will, right, to actually address some of those issues. I mean, that was just an area that I think from a First Amendment standpoint, I just wanted clarification on, because I'm not familiar with defamation law at all. With that said, there's a number of cases that I've executed, right, that fall along the same lines, where we are having an AI operate and tell the end user something, but at the end of the day, at least for right now, right, the end user is responsible. So we've had cases, back in my DARPA and DoD days, where we would have AI assess the power grid, look at the power grid. If there's a massive nationwide blackout, it would actually tell you, or an attack, it would actually tell you, well, here's how you cut off parts of the grid, here's how you stave off parts of the grid. A very dangerous operation. But at the end of the day, because we raised that question with the military, it's like, hey, we're telling you this, here's how this can go wrong, here you go. At the end of the day, it was kind of up to them to go, all right, this is what this AI is going to actually tell us. But we need to do our due diligence every step along the way, just in case this thing is wrong. And I think that from the perspective of a group, particularly like OpenAI, if we are going to do any sort of regulation, I think it would likely need to come with that clause that, hey, this could be inaccurate, which I think most people inherently know. And I think might be in a term buried in a terms of service somewhere. But I mean, it kind of seems like that overall is the solution to cases like that.
I definitely want to pick up this question of responsibility allocation as we move along here. But Eric, want to invite you in for reactions first.
Yeah, and I may well provide a bit of a prelude for responsibility in the sense that I absolutely agree in principle that any speech or content generated by AI should not receive greater protections than that we already enjoy. And in particular, the harms listed, I agree, are real harms, non-trivial harms. But I do think that effective regulation requires a question of who should be held liable and what is the likely deterrence effect on those you're intending to hold liable with respect to a particular regulatory intervention. And so I actually think resolving some of the speech questions posed by AI may implicate two other areas that I think are very unsettled on a constitutional footing that the digital age has brought forth kind of at an exponential level, that of encryption and that of open source software. Because the problem being is I see two natural alternatives if we're not holding the machine liable and we're actually holding a human individual or, corporate person liable for speech created by an AI agent. And that's the developers of the company that developed the AI or the individual user putting a prompt in. But the reason that I bring up encryption and open source are those have deep implications for the effectiveness of either of those as an appropriate locus of regulatory liability. If I'm an individual user and given access to easily available encryption tools, I can spoof my identity in so many different ways that truly tying the output of an AI algorithm to my individual identity will be very hard. You might answer, hey, you shouldn't be able to encrypt your digital identity to that level, but that's precisely why I'm saying this is nudging up against encryption if we want to hold individual those who input a prompt that results in sufficiently harmful outputs. The problem with holding companies liable is I think the cat's already out of the bag in terms of these algorithms have been open sourced, including by Meta, and are likely to continue to be so. And so there's a very interesting question lurking, which is code speech? Whether or not it is, the status of open source software has a lot of implications for speech questions, and several courts have held code as speech in limited instances. Don't take away from my remarks that code is unambiguously speech under the jurisprudential definition of the US Supreme Court, but some courts have held a few steps towards that direction. And to me, the problem is if you regulate the companies that are not open sourcing their models, then that just means that the open source models will be the source of most of the harmful AI generated content.
So Helen, I want to come back to you and I want to ask a slightly different question than we had planned on, because I think we've shifted to this question of allocation of responsibility. I think we can back into what the First Amendment has to say about it. But I guess I want to throw one other piece on the table in addition to the sort of real world complexity, the technical complexity of open source models being out on folks' laptops, on encryption, on the difficulty of watermarking. I might throw in a legal difficulty here as well, which is Section 230 of the Communications Act, which, at least if you believe its most ardent proponents, might actually afford greater protections to an intermediary that is hosting an AI model than we might otherwise afford if we treat it as a mere sort of mirror on its user's speech. So that might provide an additional problem on top of the First Amendment. So Helen, with all of that, engage with it what you will. What does the First Amendment have to say about this mess?
Well, my first point is relevant to what Eric just said, in that some if not a lot, of what AI does, I think can plausibly be understood as conduct rather than as speech that's protected by the First Amendment. In other words, I think that we could choose to understand algorithms and code as doing things. They're a set of instructions to machines rather than saying things. And if you take that point of view, AI might be considered conduct rather than speech, and that changes the First Amendment analysis, and it makes it much easier for the government to regulate, free from First Amendment obstacles. But even if we were to conclude that that AI outputs, what AI is producing is speech or includes speech that's covered by the First Amendment, that doesn't necessarily require us to understand the First Amendment to forbid the government's regulation of AI outputs to address harms. And as I signaled before, I think we should take a listener-centered approach that understands the First Amendment to protect AI speech when it furthers listeners' interests and to permit the government's regulation of AI speech that frustrates listeners' interests. Now, sometimes speakers and listeners' interests are fully aligned. They're on the same page. When speakers want to speak and listeners want to be spoken to, they want to hear those speakers. But that's not always the case. And sometimes we have to choose between the First Amendment interests of speakers and listeners when those interests collide. And this is the case, for example, when speakers want to talk to listeners who want to be left alone, or when speakers tell lies and listeners want the truth, or when speakers want to keep secrets and listeners want accurate disclosures. In those situations, we've got hard First Amendment problems because we have to choose who we're going to privilege, who's going to win, speakers or listeners, when push comes to shove. And First Amendment law sometimes permits the government to choose listeners, especially in situations where speakers and listeners are not operating from positions of equality. For example, where speakers have more information than their listeners or more power than their listeners, or maybe both. And the classic example here is commercial speech. And this is speech about the terms and conditions of a commercial transaction, speech about the price or the quality or the attributes or the dangers of commercially available goods and services. And the Supreme Court has held that commercial speech is worthy of some First Amendment protection because it's often valuable to consumers, to listeners who are making choices about what to buy or whether to buy. But the degree of that protection, again, turns on whether the commercial speech furthers listeners' interests or interferes with them. So under this doctrine, commercial speech that is false or that is misleading or is related to illegal activity, it's not valuable to listeners. It frustrates their informational interests. And so the court has held the government can completely forbid false or misleading commercial speech without raising any First Amendment problem because it's not helping listeners. And for the same reason, the government has substantial leeway to require commercial speakers to disclose accurate information about their goods. And the most famous example is the Surgeon General's warning on cigarette packaging and advertisements. Congress has required the manufacturers and advertisers of tobacco products to disclose to their listeners, to consumers, this particular health hazard. And once you know that, you can see it everywhere. It's on your cereal boxes, right? The federal government requires food producers to disclose nutritional information because it's of value to consumers as listeners. But on the other hand, commercial speech that's not false or not misleading is usually valuable to listeners, and so it gets a fair amount of First Amendment protection. And I think AI speech is in the same position. It can offer great value to human listeners, but of course, and Professor Dawson started us down this road, there's also a complicated and dark side to AI speech. And again, I think that we should understand the First Amendment to protect AI speech that's valuable to the listeners while permitting the government to regulate AI speech to protect listeners from certain harms. And I'll just give one example, and I bet my colleagues have a bunch of other examples. I'm going to flag manipulative AI speech. And by manipulative, I'm drawing on ethicists' understanding of manipulation that's unfair or wrongful behavior that involves a speaker's effort to shape their listeners' decision-making to the speaker's advantage by targeting and exploiting those listeners' vulnerabilities in ways that the listeners are not consciously aware of, so it's hidden, and in ways that those listeners could not easily become aware of if they were to try. And today's technologies, including AI, create opportunities for manipulation never before possible, both in degree and in kind. AI can identify users' vulnerabilities by collecting and analyzing huge amounts of data about us, and then can develop interfaces and interactions that very effectively exploit those vulnerabilities to get their users to spend more time online, to shed more data, to buy more stuff. And I think that this sort of manipulative AI speech should be considered a category of unprotected commercial speech, just like false or misleading commercial speech, because all of this speech, manipulative commercial speech, false or misleading commercial speech, undermines listeners' interests rather than furthering it. So my aim here is to make sure that First Amendment doctrine retains a human focus, even if it is understood to cover AI speech, to retain a human focus by attending to the effect of AI speech, its value and its danger for human listeners.
So lots we could pick up on here, but April, I want to come to you and please feel free to grab any of those threads that you'd like, but one that I'd be especially interested in, Helen's laid out a sort of a balance between speakers and listeners. It struck me in some of the harms that you listed earlier, there's yet someone else in the calculus from a policy perspective, which might be the subject of the speech. So when we're talking about deepfake pornography, for example, there might be a victim of that who is neither the speaker nor the listener, but might be the target of our regulation, or might be the beneficiary, excuse me, of our regulatory intervention. What are your thoughts about how that ought to play into the First Amendment calculus when we've got someone else implicated?
Mm-hmm. Yeah, I think, you know, the thing about AI is it allows us to do that which humans are already prone to do in a faster way and in a broader way. And so I don't think that AI is the tool that is creating or helping to create at scale these pornographic images changes really the First Amendment framework, right, with respect to that. So if the First Amendment would not protect someone from either creating manipulative content or harmful content, it wouldn't even if AI was used to help them create that. I did want to pick up on something that Helen was saying about the manipulative nature of AI content if the user is using it for that purpose. If we go back to the elections and we think about Facebook and Cambridge Analytica, right? That was what the whole point was in order to gather, like the purpose of gathering that data, building those profiles, targeting specific communities for the purpose of manipulating what their thoughts were about the election. So when we think about different viewpoints, like who has these viewpoints? Are there grassroots organizations that focus on this particular issue? There may not be, but you can manipulate people into thinking that it does based on the content that you produce with AI, right? And these profiles that you build. So I don't think that when we're thinking about the harmful way that AI is being used, that it necessarily impacts how the First Amendment would apply in those specific situations.
Let me go to Newton and then to Eric.
Sure, you know, just kind of picking up on that front, you know, I think that is where a lot of the nuance comes in, because I've had to work for a lot of sort of advocacy organizations where, you know, we do a lot of the scraping, we do a lot of the gathering and forming profiles of people, trying to lump them into clusters, but for things like how do you advertise to these folks for climate change, like campaigning and things like that. And so, you know, I guess I would say I agree with all, like both points that I've that I've heard thus far. But in terms of, I guess, the definition of manipulation, which I'm assuming has a long-standing legal definition. Okay, maybe. I think that's where we would start to need to parse that, because I do agree that obviously that behavior is going to need to stop because the democracy is on the line. But where exactly we cut that off versus where a lot of the advocates are going, where a lot of the folks who are using AIs in what I would call a positive way are going, we don't want to end up hindering them as well.
You know, just to tack on, I think manipulation is a serious concern, but I think it should be weighed against the human ability to learn. And so I think the natural consequence of deep fakes, for better and for worse, will be greater skepticism as to video content that we encounter. And so AI, I think, is necessarily a step change in the technology of information production. But the, storied anecdote of War of the Worlds coming out on the radio and convincing people that there was actually an alien invasion, this can be traced all the way back to the development of the printing press and the Catholic Church's concern over their tight control of existing information published in, at least in the Western world. And so, again, that's not me taking a position of manipulation isn't a problem, we shouldn't do anything about it, but there is a countervailing tendency, which is as information becomes far cheaper and more effectively produced, then it's used for both great and terrible ends at the same time. But ultimately, if we're harmed by those sets of ends which are terrible, eventually we become skeptical of consuming certain sources of information. And so I think we may be deeply limited absent development of effective watermarks or other techniques. I think what the status quo equilibrium might be is if you truly want to know what a politician is saying, go to a town hall or go to a debate, because otherwise there's a much higher risk that the content you're consuming in a relatively unregulated online context is just AI generated deepfakes. But if everyone knows that, that's an interesting equilibrium in which to assess what are the net social harms resulting from manipulation that we're seeing in the short term, in great part due to the extent to which the average listener is conditioned on an equilibrium that is no longer the case surrounding information production.
I mean, I want to put that back to the panel, I guess, as a jump ball. That sounds like a terribly dystopian world where we are flooded with information about the sort of core function that we exercise as citizens participating in a democracy, and all of the information that informs our decisions on that front is fundamentally untrustworthy, and we need to be really cynical about it.
We're already there.
Just FYI. All right, so we're in a very terrible place. Are we okay with that? I don't know.
Well, I actually, I thought Eric was offering an optimistic point of view. Yeah, right?
Yeah.
That you had faith, like this morning, Scott Skinner Thompson says he has sort of faith in humanity to figure it out. I don't know that I have that faith, but it makes me feel better to know that some people do. So thank you for that. So, but there might be room for regulation, right? If we're not comfortable with the status quo, and I think there's all sorts of reasons we should not be comfortable with the status quo. I focused my remarks on manipulative commercial speech, number one, because there's so much of it. And also number two, because the First Amendment rules are much more listener friendly in the commercial context than they are in the political context. But we can also find models for listener-centered frameworks in the political context. Citizens United, whatever you think about it, every justice on the Supreme Court said we are corporate campaign speech is valuable to listeners. We're not making an argument that corporations have autonomy or dignity interests themselves that are worth protecting. We're saying that corporations are major players in society, major players in economy, and so what they have to say can be valuable to listeners. And where the majority and the dissent disagreed is whether or not unlimited corporate speech is ultimately valuable to listeners or actually detrimental to listeners. The valuable theory is the more speech is always better, and the detrimental theory is, well, actually at some point, highly resourced speakers can flood out competing views, so the listener is exposed to an impoverished marketplace of ideas. And that's not the only example of a listener-centered framework in the political context. So I think there's also ways to be more interventionist.
All right, I'm sufficiently heartened. Let's spend our last few minutes before we open it up to questions with, I don't know if this is a lightning round, but let's call it current events. Why not? The Supreme Court is this term, and in recent terms has a lot of cases that might bear on this topic on its docket. April, I'll turn to you to walk us through what's happening at the Supreme Court.
Right. So one of the cases that was argued, actually there were two cases that were argued on March 18th. And so one was Murthy v. Missouri. And so that's the one of two job owning cases. And Eric, you mentioned Solomon. I think that whole job owning terminology comes from King Solomon and something that he said at some point in time. And these cases really center around, can the government vigorously persuade, some may say coerce, individuals or companies, in the case of Murphy, social media platforms, to engage in some censorship or engage in some conduct that is based on someone else's speech. So in the Murphy case, this was when we had the Biden administration reaching out to Facebook, Twitter at the time, now X, other social media platforms, asking them, telling them, kind of threatening them, short of coercion, if you ask the Biden administration, to take down posts that focused on COVID misinformation, at least according to the administration. And so the First Amendment is implicated because, of course, when we're talking about content moderation, we're talking about either de-amplifying posts that are on these sites or actually removing them. And so Missouri and Louisiana brought an action against the Biden administration saying a couple of things. One, that the states actually have an interest in making sure that the administration doesn't undermine the First Amendment rights of its citizens. If you listen to the Supreme Court argument, I'm not sure that any of the justices really bought that. And a lot of the discussion really kind of focused on standing, like who has standing. The standing really centered around traceability, right? So one of the things that we know about these platforms is that they engage in content moderation all the time. That's one of the reasons why they have Section 230 protection, right? They're going to be moderating. Sometimes they're going to not take down something that might cause harm. Well, they don't have to worry about liability because of 230. So they're engaging in this moderation. And so the question with respect to traceability is, if someone's post was taken down, was it taken down because of the pressure from the Biden administration or because the platform decided on its own, this post needs to come down? So there's this traceability issue. The other standing issue that the court spent a lot of time talking about was the redressability issue. So even if the court rules in favor of the plaintiffs and the respondents in the Murphy case, how do you redress it, right? The posts are already down. The posts were very specific to a particular moment in time. So this pandemic that was going on, an election, election deniers. So a lot of the politics and a lot of the statements that were being asked to be moderated were specific to that time frame. They no longer exist. So there are these issues with respect to redressability as well. The other really important point that the justices spoke about during the oral argument was, at what point does the government's involvement, maybe even partnership with these social media platforms, make the content moderation a state action? So if we're talking about the First Amendment only applies if we're talking about, the government engaging in some conduct. If it is focusing on private conduct, then you have to show that that private conduct has been converted into a state action. And so the question is, was that entanglement, if you will, did it rise to the level of actually being a state action? The other jawboning case, which didn't really involve technology, this case, it feels as though the court's going to rule in favor of the NRA, where you had the director of the New York Department of Financial Services advising, kind of threatening, persuading insurance companies and banks not to do business with the NRA because of opposition to the NRA's promotion of gun rights. That's a much easier case as far as like the threats that were being made. It's clear to show the traceability, the redressability. So it will be really interesting to see what the court does with that case. The last case that I want to just kind of highlight, so this is the net choice case. And so this is an interesting case because, with the Murphy case, you've got the federal government trying to get these platforms to take down specific content. In the net choice case, you have the state governments trying to prohibit these social media platforms from taking down or engaging in certain types of content moderation. Again, kind of the facts that gave rise to the net choice case was this perception that social media platforms have some animosity towards conservative leaning statements or conservative leaning expression, that viewpoint. And so two interesting cases, one out of Texas, you have the Fifth Circuit, which upheld the Texas law, and then you have the Florida case where you have the 11th Circuit striking down the Florida law. So we've got this split in the circuits. And really the question comes down to whether the states are able to moderate content or restrict the moderation of content for the protection of the citizen. So again, we see the states positioning themselves where they are protecting the First Amendment rights of others. Also, Helen was talking about the listeners, kind of the rights of listeners. We see this in the Net Choice case as well. So if the social media platforms are removing tweets and removing Facebook posts, there are those that might be interested in hearing that or seeing that. And so, they're harmed by it as well. But again, it goes back to, are we talking about a private platform? Is this platform a common carrier such that the government can regulate? It'll be really interesting to see what the court does with that case as well. So those are kind of the three cases that the Supreme Court's wrestling with.
Well, and maybe just to put two sort of recent examples where this has blown up for artificial intelligence on the table. We have both the recent example with Google's Gemini model creating diverse soldiers in Nazi regalia, and then we've got the Gab, sort of racist chatbot that is sort of intentionally being configured to spew out a lot of racist ideas, and then calls in from both political directions, have not manifested in legislation yet, but that might call on platforms to do different pre-prompting, different training, different moderation, both inputs and outputs to deal with that. So we might see these issues bubble up. With that, I want to come down the panel from the end, start with Eric, then to Newton, and then to Helen for a final word before we go to questions.
Awesome. And so I just want to kind of double click on, given the current events prompt, two areas where I think we are going to see definition that both implicates the future of AI models, but also a variety of interesting speech questions. The first surrounds encryption. And so I would encourage the interested to consider the tornado cache case currently. And setting aside any of your beliefs in terms of whether we have a right to economic and financial privacy in the digital realm, that case itself both implicates encryption rights as well as open source questions, because the developer of Tornado Cache is being held liable for end uses of a piece of open source software. Well, the developers, I should say, are being held liable for the end uses of a piece of open source software. That has implications for the effectiveness of regulatory interventions with respect to AI, but it also, to me, encryption in the digital age is an important shield that provides associational and speech privacy. And so there is a decent bulk of jurisprudence protecting associational and speech privacy in certain contexts, mind you. And so it's, again, not absolute, but very interesting questions in the digital age for speech and AI raised by both encryption as well as the extent to which developers can be held liable for end uses of software that they let out into the wild, so to speak. I'll end there.
So, all very fascinating cases. I think when it comes to open source capabilities and, even open use capabilities, like the things that OpenAI pushes out, I think it's important for us to remember why we started doing open sourcing in the first place, right? Open sourcing goes way back, but it got very popular in sort of the mid to late aughts. And the overall idea, the overall goal wasn't for this thing to, be completely ready for prime time, be completely ready for operation. The onus, in fact, if you were going to do that, was really on you and your organization. Really, the idea behind it was, I'm an organization, I'm a company, I'm a grad researcher who has a model that I think shows some promise, or I have some code that I think shows some promise, and I want the community to chime in. Tell me what's wrong with it. Tell me what's right with it. Now, obviously the OpenAI example and even what Meta AI is doing, those are substantially different in that these companies are actually, they're making money off of the fact that these models exist. They know that some folks are going to be depending on it, but they still do have those roots of, tell us how this is doing. That's what the little thumbs up, thumbs down button for ChatGPT is. So, I guess we really do have to, at least in the current times, think of what the balance is between restricting certain things that that these models can say or do versus leaving room for them to actually get better. Because the purpose of that open sourcing process is for them to get better. They cannot get better without the public using them. And we do need to foster a public that effectively is educated enough to be able to use it and use it responsibly. Should there be guardrails there where we get into, who's responsible and who's not? I don't want to dive into that. But I do think that it's important to remember why open sourcing exists in the first place. It was never to sort of have to say that you have a ready to go product. It's to say, hey, I want you to test this out. I want you to try this out.
Helen, a final word before we go to Q&A.
So as Professor Dawson was going through the list, I was struck by how a number of the cases involve First Amendment challenges to what we might understand as non-traditional forms of speech regulation. So the job-owning cases are complaining that the government speech is usually exempt from free speech clause review. The government can usually talk as much as it wants, and your remedy, if you don't like what the government says, is to elect yourself a different, better government. But that the government's speech by itself doesn't violate the First Amendment. And here, the government, through its speech, was trying to shape its listeners' choices. And the question in these cases, the First Amendment question is, when, if ever, does the government's speech step over the line from permissible persuasion to impermissible coercion? And the less the government can speak, that takes away a very commonplace but non-traditional regulatory tool. And then the net choice cases have to deal, it's a First Amendment challenge to state laws that try to regulate platform self-governance, right? They're trying to shape the speech on their platforms through markets and norms, right? Through their terms and services, they're trying to shape their users' norms. This is what we allow, this is what we don't allow, and here's how we enforce it. And through markets, if you don't like the rules, well, you could choose another platform. And we're going to learn from these cases whether or not that sort of self-governance, corporate self-governance, is going to be permitted as a non-traditional regulatory tool. And Blake, Eric's mention of open source reminds me of another tool that you might sort of think of as a non-traditional regulatory tool in the speech realm, which is copyright, which is a funny little beast of its own.
Yeah, and maybe worth very brief mention here just to say there's a literature that copyright scholars have called the weaponization of copyright, to use it as a regulatory model for harms, whether we're talking about privacy or specifically in the context of AI, to achieve some broader set of regulations that are beyond what we traditionally think of copyright as being for, to structure transactions around the dissemination of creative works. And one of the interesting things about the ongoing litigation against many of the AI platforms involving copyright is we actually are very unlikely to see First Amendment challenges. And in fact, some of this litigation is starting to advance. And that is because under copyright law, we typically cash out First Amendment questions in a different way. We question whether the use being made is fair, which prompts an entirely different set of questions and equities. And so I think there is a lot of interest and potentially hope from some quarters that copyright might be used effectively to structure some of what the platforms are doing or to regulate what some of the platforms are doing without having to worry about some of the First Amendment harms that we have discussed. With that, I'm happy to open it up for questions. As our tradition goes, I'm going to come to a student first for questions. And there's a corollary to this rule, which is when it's late Friday afternoon and I see a number of great students who have hung out all day, I will call on a student for the first question, but I'll keep going with students as long as there are student questions to come. So I see one down the front row. Catherine, as the microphone comes to you, I can only say, I don't think I have ever had a student in my office hours as often or as angry about the net choice cases as Catherine. I anticipate a question on that. Go ahead.
Sorry to disappoint. I had a question for Professors Norton and Dawson. As we're thinking about regulating AI speech, I keep thinking about the Supreme Court's continued and increased adherence to the idea of originalism in history and tradition and custom. And I'm thinking about the Stevens holding that to create a new unprotected category of speech, there needs to be a longstanding history and tradition. And to quote the net choice cases, not in their wildest dreams could the founders have imagined open AI. And so I'm wondering, how do you see the Stevens holding complicating or playing into the regulation of AI generated speech?
Yeah, that's a great question. Catherine, and my first reaction is it shows the limits of originalism as a tool for responsible constitutional problem solving. But I would still, I think there's ways to limit and distinguish. So Stevens, United States versus there's a handful of categories of speech that the Supreme Court over the centuries has held as entirely unprotected by the First Amendment: defamation, threats, obscenity, child pornography, a couple of others. And for the longest time, the court explained that these are unprotected because they're low value, First Amendment value, and high harm. They're not doing any First Amendment work, so the government should be able to regulate them. And then in the Stevens case in 2010, the court said, oh, no, we're not doing cost-benefit analysis. We never did it, even though they did. We're not doing cost-benefit analysis. The only way you can identify a category of speech that's entirely unprotected by the First Amendment is to show that there's this long history and tradition of regulating it without triggering any First Amendment heartburn. So it suggests, and lower courts have looked at this to decide, well, I guess that non-consensual pornography is not unprotected speech because, of course, there's not a long-standing history tradition of regulating something that hasn't existed. But on the other hand, a number of those state courts to consider regulations of non-consensual pornography have held that they satisfy strict scrutiny. So I think what Stevens will do is to force courts to do workarounds around its holding and either characterize the government's regulatory target as content neutral and not content based, so lower levels of suspicion, or in rare circumstances, hold it, and I do think it will be rare, holding that the government's regulation nevertheless passes strict scrutiny.
Mm-hmm. Yeah, great question. And I think what I would add is your question kind of illustrates the problem that we have in the judiciary, the executive and the legislative branches, right? Which is technology is moving so quickly and our government moves slowly. I mean, even if we think about lawyers and law professors, right? This is a wonderful conference, but most law professors aren't thinking about these technological issues as much as we need to, especially since you and your colleagues, you will be dealing with this as lawyers. So we're very slow moving as institutions. I think having listened to the arguments, my sense is that the court will decide these cases, these complex kind of technological cases, on the narrowest grounds possible. So if you think about Murthy, I think they're going to rule on it on standing, right? That's an easy way to go ahead and resolve it and to give these issues time to marinate, to help the justices kind of wrap their heads around these emerging technologies. You know, they're doing better, but they don't live in this space either. So I don't think they will craft new frameworks or new rules. I think they will go incrementally. I don't know if that's to our benefit. And then I just want to very quickly kind of tie that into Congress. Congress has had a lot of discussions and hearings. There was a Senate hearing just recently on AI and the elections. Great hearing, a lot of great discussion, but we can't just have discussions. I don't know when we're going to get legislation, right? And your question kind of illustrates that point, that these things are moving very quickly, but we're moving very slowly.
And I just tag onto that and say that this is the copyright point, which is copyright law is the only real law on the internet. It's the only place we've applied regulation to both internet platforms and internet content for the better part of the last 3 decades. With that, any more student questions? And if not, I will go to the rest of the audience. I see a student of life, Mike Boucher, right here on the right side. Over to Mike, and if you could wait till the microphone comes to you.
Let's hear. One thing that often strikes me about AI is, in a legal context, is that the presence of the word AI seems to act as a magic talisman to activate complexity that doesn't have to be there. So, for example, there's much made of the non-consensual pornographic images produced of Taylor Swift by AI. But if we went to Taylor Swift and said, fantastic news, we've looked into it, actually they weren't produced by AI at all, I doubt that she would say, oh, well, forget the whole thing then, I'm not bothered. And similarly, many defenses of AI are made by the fact that it's just wildly complex. But when I taught, I used to tell my students correctly that if we printed out all of the specs and manuals and so forth for the Boeing 747, it would weigh more than the plane. And yet, I bet that when Boeing gets sued about these problems they've had with their aircraft, they don't successfully mount the defense that, well, geez, we got everything right except this one bolt, and it's just, this plane is just hopelessly complex. We can't possibly be held liable. If they build a plane that's too complex to operate, they're not allowed to have it. Problem solved. So why are things like the Swift case and the complexity defense for various things allowed for AI, but for nothing else?
Mike, it's a great question. I think it links to a discussion during the earlier panel about which takes primacy here, the technology or the law, and we might ask ourselves.
I can withdraw my question.
No. I'm linking it as I think it's important. Why does it matter that AI is so complicated? The law is allowed to have simple instrumental goals that can ignore that complexity. Reactions from the panel. Newton, you look itching to jump in.
I was just pondering. No, I mean, I see your point with respect to particularly the Boeing defense, and it is. I think when certain things exhibit specific kinds of emergent behavior, you get past the point where it's just complex, and when they exhibit things beyond just normal use, now you start to get to the point where, okay, we need to actually do some regulation about this. Social media is not that complex of a tool until 1 million people are on it. Then it becomes more of a complex tool. Then it has an impact on the democracy. Then we start to ask ourselves, should we regulate it? Now, I don't know if we regulate it via some mechanism through the First Amendment, or we just regulate it through another mechanism. But I do think that, it having such wide and critical use cases allows it to be a candidate for some kind of regulation. Now, what kind of regulation that means, whether or not that's regulation on the development of it or the use of it, I think we need to have some nuance there. But I mean, yeah, I guess I would agree with, it's not so complex that we shouldn't think about how to regulate it. But I do fall back to the notion that it is out there, particularly the ones that we're talking about, ChatGPT and things like that, not some of the other services and robust models, but some of those technologies are out there as open source capabilities that are, effectively being tried out. And I think that if we're going to regulate anything, it should be about the messaging, the terms of that, the making people aware of, its inaccuracies, so on and so forth.
Let me grab the other half of Mike's question real quickly and ask, when we evaluate the application of the First Amendment, does the Supreme Court do that in a technology neutral or agnostic way, or does it take into account the characteristics of the new medium? In other words, is the new attributes that AI has brought to the table, does that warrant some new consideration, or are we just old wine in new bottles?
Well, the example of non-consensual pornography and the example of defamation, I mean, the regulatory interest, I think, is often the same, regardless of whether the non-consensual pornography or the defamation is produced by a human or an AI source. So that I agree, the law shouldn't turn on the AI source of non-consensual pornography, because the harm to the victim doesn't turn on the human or non-human source. There might be some situations where the nature of AI exacerbates the harm or makes a more challenging regulatory target, which models. And if that's the case, if we're seeing new regulatory models, that might require the court to be tech sensitive. But often, I agree, often these challenges do not require the court to be tech sensitive.
All right, with that, I'm getting the hook from our host here. So please join me in thanking our panel for the wonderful discussion.
Thank you, guys. Well, thank you, Blake, and our panelists for a terrific panel to end the day. And I want to thank everybody more broadly for an amazing day. We had some really great insights about the intersection of artificial intelligence and law. I know I learned a lot. I just want to again thank a couple people who worked so hard to make this come together. Professor Suzette Malveaux, my co-organizer here, the staff at the law school, Dean Innes, Brad Bernthal, the amazing team at the Silicon Flatiron Center, Shannon Sturgeon, Christine McCloskey, Nate Mariotti, and Shara Schnickran. Law School Events Coordinator, Lindley Bell. The IT staff who are amazing here, and the student volunteers who are terrific, and the fellows. And last but not least, our terrific panelists who came far and wide and shared their expertise. So thank you so much.